Good morning, Your Honors. The matter before the court this morning is the case entitled Duggento v. Longe, case number 24AP011. Representing the appellant, Erica Duggento, is Jacob Oblock. Representing the appellee, Roger Longe, is Peter Anderson.
All right, and appellant's counsel, please introduce yourself and your client, and you may proceed.
Thank you, Your Honor. Good morning, and may it please the court. My name is Jacob Oblock, and I represent Erica Duggento, the appellant. I'd like to use my brief time today to start by emphasizing one point. If I have time, I'll get to a second. But the point I'd like to emphasize today is this double bind, from our view, the double bind that the trial court placed on this lifeline primary caregiver of two girls. We see it as untenable that the trial court held against mother two primary choices. One, not agreeing to modify the contact schedule at father's request in years past, and two, agreeing to accommodate father's work schedule by picking up and dropping off the children to school on his time. We'll say that family attorneys often advise clients to co-parent with the other parent, try to make reasonable accommodations where it's possible for the children's benefit. And it appears to be exactly what mother did in this instance on her own. I think it would be bad precedent to basically broadcast to litigants and attorneys that the trial courts might hold against a parent and call it controlling where they do that accommodation. And as we argued in our brief, father's testimony was, yes, that it was mother's idea to help him out in that instance. But he testified, he even agreed in his testimony that it was, quote, reasonable to say that this arrangement that you and mother worked out years ago has worked pretty well over the years, unquote. I mean, I think if this message is affirmed, I do think that attorneys will have to start telling clients to just say no and have them, have father figure out his own time, his own issues. Don't help out. It could be used against you. And if he can't figure it out, just move to modify and take that time away from him. I don't think that's the message that I don't think that's the message that trial courts in general want parties to be taking away from this. And then the almost irony here is that the trial court appeared to hold against mother also the exact opposite. Mother never had agreed to a 50-50 schedule throughout the years. That's undisputed. It's unclear when father made all of these requests for more time. Some of them could have been pre-June 2019, which is when the order came out from this trial court, not the same judge, but this trial court, denying him that very request due to concerns over his drinking and actually analyzing the best interest factors. And mother apparently did decline some of his requests to modify the schedule. And the trial court used the words, quote, father deferred to the court order, finding it simpler to follow than engage and be denied by mother, unquote. And that finding is incredibly remarkable, given that the trial court in its very previous breath had just held against mother her own declining to agree to father's requested modifications. So in essence, as I see it, the trial court basically told mother that she was at fault for sticking to the order and that she was at fault for father sticking to the order. And this is all against that backdrop of this very trial court denying father's original request. And if the trial court is holding that against mother, which it didn't explicitly say, but the whole tenor of the order appears to be holding that in addition to the other that I just mentioned, that would be unreasonable to hold. I mean, the very trial court's decision. I would also ask this court to review the best interest factors as reviewed by the trial court. From our view, and very briefly, we believe that what the trial court in essence did was went through all the facts it felt were relevant from the testimony. It reviewed the factors, it counted them, it described the factors, it quoted it cited to the correct statute. And then it reviewed some of the facts. It found that most of the factors were equal. Mother has been and always was the primary caregiver. And the trial court described the relationships the children had with their various family members on both sides in Vermont and in Georgia and with the two parents, and then just declared a winner. We don't believe that that is adequate analysis that would support the violent dislocation that this trial court ordered in this case. The best interest factor is the high hurdle that appellee had to clear. The trial court declared that he had cleared the hurdle, but we do not believe the trial court adequately explained how or why he did so. And for these reasons, in addition to the ones we argued in our brief, we believe this case should be remanded. And I would reserve my time for rebuttal.
All right, very well. Counsel for the appellee, please introduce yourself, your client, and you may proceed. You're muted, sir. You're muted, sir.
Apologize, Your Honor. Good morning, Your Honors. Peter Anderson on behalf of the appellee Roger Longe. I find it interesting that appellant's argument ignores the underlying premise upon which this whole proceeding came before the family court, which was Ms. Duggento's intention to attempt to relocate these children to Georgia. And this is a relocation case, and this court has addressed frequently what the court must be considering in these matters. There was extensive evidence put forward by both parties regarding the best interests of the children. And I believe the court has consistently held that you're not going to disturb a family court's findings only if viewing the record in light most favorable to the prevailing party and excluding the effect of modifying evidence. There's no credible evidence to support the findings. Appellee asserts that there was adequate findings and evidence to support the findings and conclusions that this trial court came to. The representation that Ms. Duggento has been the lifelong primary caregiver was arguably a disputed issue. The children spend nearly 43% of their time with my client during the course of the years preceding her efforts to or desire to relocate with the children. My client argued to the court that the dislocation or the relocation of the children would result in a significant impairment and disruption to his contact with the children that was significant and ongoing. And it is the appellee's assertion that the court reasoned through both the factual evidence to support the basis for a finding of a change in circumstance, and as well its assessment of the factors under the rights and responsibility provisions of our statute, section 665, that says what the court has to consider in deciding how the award of rights and responsibility ought to happen. And here the court faced the Hobson's choice of either letting these children go to Georgia and be dislocated and disrupted from their contact with their father that had been ongoing and consistent, versus the change in the change in custody that maintained the children's connection to their present home, school, and communities, and their relationship with their father. Appellant argues that, well, mom said she wasn't going to go, but I don't think that Ms. Duggento had the right to both advocate and insist upon the court deciding her motion to allow the modification, to allow the relocation. And without withdrawing that motion, the court was left with either the decision to either modify rights and responsibility and the children stayed in Vermont, or allow her to relocate. And based upon the evidence and the analysis of the trial court, I firmly believe that the trial court's decision was amply supported by the evidence. There was a reasoned decision made, citing all the relevant factors under the statute, and I believe this decision ought to be affirmed. I'll rest my argument there, Your Honor.
All right, thank you, counsel. Does the appellant have any time remaining?
Yes, Your Honor. Appellant has 44 seconds remaining.
Counsel, you may proceed.
Thank you, Your Honor. Just a couple points in response. It was just argued that the lifelong primary caregiver status of Ms. Duggento was disputed. That may be. It may be that Mr. Longe now disputes it or did dispute it, but both of the orders in question here, the 2019 order that preceded the 2023 order and the 2023 order, both acknowledged that mother had always been the primary caregiver. So while his client may have disputed it, it was not the trial court did not dispute that fact. The last point I would make in response is that much of what Mr. Anderson just argued, as far as the facts supporting a decision by the trial court, goes to the real substantial and unanticipated change analysis, which that part isn't disputed. The court has the discretion. Of course, the trial court has the discretion to decide that, the amount of time Mr. Longe, the father, spent was substantial. And I see that my time is up, Your Honor.
All right, thank you.